The respondent in this case had a 9-story building and turned it into a hotel. The respondent led the appellant to run a recreation center on the 3rd floor. Later, the respondent decided to close the hotel business and informed the appellant that they would no longer require the service provided by the appellant. However, this appeal revolves on the principle highlighted in High Court, which is Mareva Injunction. The High Court dismissed Mareva Injunction as Malaysia possesses no power to grant restraining orders of the nature described in the principle. It was later held by Raja Azlan Shah, overruling the decision of the High Court that the High Court has jurisdiction to grant a Mareva injunction in appropriate circumstances. Section 45 of the Supreme Court Judicature Consolidation Act 1925 enables the court a wider discretion to grant an interlocutory injunction. In Malaysia, the provisions of paragraph 6 of the Schedule to the Courts of Judicature Act 1964 are equivalent of the provisions of the Section 45 of English Court of Judicature Consolidation Act 1925. Hence, Mareva injunction could be applied by the High Court in Malaysia. Although it was decided that Mareva injunction can be applied in Malaysia, the injunction were not to be granted in this case. If the injunction were to be granted, it would be entirely ineffective to the benefit of the appellant, as the money would be held for the benefit of the creditors generally. To add, the result also would be that a plaintiff would require the defendant to set up a special fund to meet a claim not yet proved, or the effect of the injunction might be to give the particular plaintiff preference over others' creditors. The appeal was dismissed with cause.